night. We have 5 board members: Julie Cook, myself, Tom Nakala, Jeff Ritter, Bill Tiegelman, and our newest member,
Hey, well,
whose name is Sharon Pierce. We welcome Sharon to the board. She's not new to public boards or whatever. Spent a number of years on the planning commission and has sort of come out of retirement to come back and help us out here on ECA. So we look forward to her input and her knowledge.
thank you.
Next will be the adoption of minutes. Or no, excuse me, I need to adopt the agenda first. I would like to add under new business a resolution that's been given to us for in regards to Alex Sharp and his leaving the board.
Okay, I move that we adopt the agenda as written with the addition of a resolution under new business. Resolution regarding Alex.
No, second.
Okay, we have a motion and a second. All in favor? Aye.
Aye. Aye.
Okay, minutes from August, whatever it was.
25th. August 25th.
August 25th.
Okay, I want to,
Yes.
I'd like to commend Julie one more time for getting everything that was important. It is a very condensed and easily readable presentation.
Thank
It's
you.
just a kind of amazing job. Thank you.
Thankfully, it's on YouTube, so I can revisit. Thank you.
So I move the adoption of the minutes from August 25th. 2021.
Second.
Motion's been made and seconded. All in favor? Aye. Okay, we've got that taken care of, so now we will move into the public hearings. Our first public hearing will be SUP 21-9-4, Jenkins on tax map 48-23, and the tourist home. So we will ask the applicant or his representative to step forward and give us his presentation. Over to you, Ron.
Good evening, board members. Mr. Makala, congratulations on your ascension. Ms. Pierce, welcome.
Thank you.
I'm, of course, Mike Brown. I represent the applicant, James Jenkins, in connection with this application. Mr. Jenkins is also here this evening. I won't take up a lot of the board's time with summarizing the application. It's fairly well spelled out in your materials. The application itself sets out the proposed use of this dwelling for a tourist home use. There are a number of photographs of the dwelling in your materials as well to help you sort of orient yourself to what's going on and how it sits on the property. The Planning Commission at their meeting last month voted to forward the application on to this board with a recommendation for approval with only the staff conditions being imposed on the special permit. One recent development in connection with this application that I wanted to address to the board, Mr. Curry reached out to me this morning to raise a question about whether the applicant had obtained necessary building permits for the renovations that are going on in the dwelling. You can see from the photographs that there's quite a bit of renovation work taking place. The application itself states that Mr. Jenkins had met with zoning staff and had been advised that he did not need to have any permits in connection with the kinds of renovations that he was making. Now, at the time of that conversation, in looking back on it, it appears to me that when speaking with Ms. Summers, he was really mostly referring to the exterior renovations. There was a front porch that was being rehabilitated. There was a back deck that you see pictures of all of these that was being repaired and replaced. And Ms. Summers had advised him then that he did not need any permits for that, provided that the porch or the deck were going to remain within the same footprint, that they were not going to be expanded at all, and that is the case. But again, in light of Mr. Curry's question, I went back to Mr. Jenkins, and we have attempted to reach out to Mr. Cornell today. There may be renovations in the structure that do, in fact, require a building permit. We're not sure. We haven't been able to speak with Mr. Cornell directly about it. But Mr. Jenkins is not the kind of applicant who wants to skirt things. In fact, he's very concerned that he doesn't want to do anything without the appropriate permits. We've tried very hard to follow all the rules and do everything correctly. So we would ask the board respectfully that if you are inclined to grant the special permit, that you impose as one of the conditions, as an additional condition, that the applicant must obtain and comply with all building permit requirements as required by the building official before the structure, of course, could be used for any kind of occupancy. So that's really all that I have to present to you. Of course, both I and Mr. Jenkins are here and are glad to answer any questions that the board may have. Yes, ma'am.
How are you?
Good, thank you.
My only question was, it looked as if the kitchen and other parts of the first floor weren't entirely finished. Maybe that the pictures were taken
Yeah, no,
earlier.
the kitchen definitely is in a state of being refurbished. That was one of the things that Mr. Jenkins, he can describe it for you. Go ahead.
Yeah, we haven't finished it yet.
Yeah, so I was just wondering, so you're not ready for the 6 people to be coming out?
Oh, no, not yet, no.
So if we issued a permit, we should maybe have a date when it actually might be available, the permit might be of use to you, right? In other words, it doesn't look like you can accommodate 6 people right now.
No, we're not paying already.
Yeah. No.
I think in the granting of the permit, we basically say that the permit will be granted by the zoning administrator when the building inspector signs off on any permits that were required for the renovation.
Yeah. I think that covers the concern.
Right, that way, it's,
because frankly, it could be several months before the
yeah, we
structure.
don't want to put a drop dead date on when the work has to be done. So.
Aren't you typically required to get a certificate of occupancy for this, actually sign off on it?
Once the process is complete, Mr. Cornell will issue an occupancy permit.
Right, so
That's right.
So,
That's right. So we've got to have that before.
Well, it depends on the nature of the work.
That's true. That's true. But I think looking at the photographs.
When the building inspector's happy,
Yeah.
he'll tell Michelle will grant the permit.
I have a question. James, this is the shear place, correct?
Yes, ma'am.
Yeah. And so is it just for the main house? What about the cabin?
Just the main house.
There. None of the cabins are involved in the application.
Okay. Thank you.
And basically, I think you just basically stated that they're really not habitable.
There's one small structure. You can see it in some of the photos. It's marginal as to whether it would be habitable or not. I talked about that with Mr. Jenkins. The theory is that maybe at some point in the future, they might, it would also need a good bit of work. But at some point in the future, they might want to use that, depending upon how things go, in which case, as I explained to Mr. Jenkins, we would have to come back to the county and seek an amendment to the special permit.
Yeah, basically, this house is a 3-bedroom.
Yeah, that house, that's right.
We can add in that it's going to be a 3-bedroom structure.
The pictures of the cabin actually clearly identify that it is not part of the
Yeah,
application.
that's right. Yes, ma'am.
Okay, is that questions from the board, or is there anybody in the audience that wishes to comment?
Open it up.
Thank you, I was going to say that, and that I said we were going to public hearing, but I did not use the word open to do with this. The public hearing was open prior to Mr. Brown's comments, but we forgot to use the correct wording, so let the record show. So I will now once again ask, is there anybody that wishes to speak further on this application? If not, we will declare the public comment portion of the hearing closed. Are there any more comments from board members? Hearing none, do I hear a motion from any of the board members?
Well, I'd like to do it since it's in my district,
Yeah.
on my road.
Yeah.
And I would like to make a motion to approve as submitted.
With the staff recommended?
Yes.
Okay. And would you like to amend it to add the condition of the building inspection and certification of occupancy?
Right,
That's what I'm-
yes, please.
Okay, and just to be clear, we should read it back, particularly on the conditions, and then we also have our fire extinguisher and
I will second
smoke
Sharon.
detector conditions that we normally apply.
I thought we added those into the code, so we no longer needed to include them.
I wasn't aware of that. We could.
So I will second Sharon's motion with the staff recommended conditions, which are a maximum of 6 people. No food service will be offered to renters of this facility. This permit terminates upon the sale or transfer of the property. And she also references the applicable Rappahannock County Code sections 170-36A and K, which I believe cover those standards that you're mentioning. And then with the added condition of the building inspection and certification of occupancy. Is that correct, Sharon? Okay.
Okay, we're all happy with that?
Well, there's a second.
Okay, all in favor of the motion?
Aye.
Yeah, please, a second.
We got a second, right?
Yes, we had a second right here. So all in favor of the motion?
Aye.
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 Opposed? Motion passes. Good work.
Thank you all.
Okay, moving on. Our second public hearing is special use permit 21-9-3 Turner, tax map 13-94A for an accessory dwelling unit. And prior to opening the public hearing, I would just like to state that having gone through the information today, the application is lacking. It does not have a plat map and the necessary measurements and designations on where exactly the house and the auxiliary unit lie on the property. And that's a VDOT map, that is not
That's
a plat map. And
Yeah.
and because of that, I'm going to abstain because I have some questions that pertain to that, which I can't ask because we don't have the information. So I'm going to leave it up to the four of you to decide whether you want to continue along the way with knowing full well that if it's a tie vote, that the application will fail. And I'm, quite honestly, I tend to be in favor of it, but there are some questions in regards to the fact that there are 2 dwellings that already exist on a 4.3 acre lot, and how that happened and where they're situated. And these are the questions I had and wanted to have answered, which without a plat map, we can't do that. So
Well, there is this photograph.
that's not a plat map. It does not have measurements on it.
Can you table this and
We can.
for complete application?
And this is where we've done before, and it gets confusing, because whether it's a recess or we continue it, if we can open the hearing, and then I believe continue it to our next meeting. And particularly with the folks that are here right now, I don't believe there's anybody here that is in opposition, and we could go through just the initial presentation, but it would be up to you all whether you want to complete the process.
Just to remind the board, the terminology in our rules, section 3.6, is the term continued shall mean a hearing that is rescheduled to a later date without having been commenced. A hearing is commenced when it is open for public comment by the chair. The term recess refers to a hearing which has been commenced and then rescheduled to a later time and placed for completion.
Right, but
Okay.
one of them had to do with advertising, that's how I get confused. So
I think if I could suggest, I think if you open the public hearing this evening and then simply recess it to next month, then it won't require any additional advertising on the part of the county. Rather than if you continue it without any action tonight at all, then it has to be re-advertised.
I agree.
That's what the rule says.
So-
Thank you.
And you could also open it and close the public comment period and deliberate in a future meeting.
Right, which
Should this
actually I
plan
would
have no impact
prefer
on
not
if
to.
somebody would want to come and talk about it?
Right, I would not want to close the public comment periods, because there is, I don't think there's any need for that.
I have an aside here. We do occasionally get incomplete applications. Is this because they just put the applications in those slots in the building office and nobody checks them to accept them?
It is the obligation of the county to ascertain that the applications are complete
Right,
prior to them being presented to us as a board.
right.
And if that doesn't take place, and that has happened in the past recently with deeds and whatever, then, it's no fault of the applicant, it's the fault of the county, but like I said, I'm not comfortable proceeding.
No, me either. I want to see what, I need I'm like an information hound. I just have to know what I'm doing before I do it.
Right, well, that's what it
That's a big
is.
rule I have.
It clearly states in the application that there's supposed to be the plat maps with measuring, a plat map, which has the survey, which so you can look at that and determine measurements and how close the buildings are, whether the setbacks are being met, this type of thing. And without that, that can't be determined. And like I said, there is a question that relates to this, in that there are two dwellings on a 4.3 acre lot at this point in time, and how did that happen? And exactly where are they located on the property and whatever. So that's my questions.
But the additional, it's not, you're not making a third one.
No.
Yeah, it's just that it's already there. Yeah.
They are already there, but that's, there are questions that need
He
to
came
be
down to
answered.
bedrooms, like there's
Right.
one bedroom in one house and two bedrooms in the other house, so it's a combination of three, but anyhow. And I'm glad to hear it's not our problem, it's not our fault, and it's.
And so we're sort of getting into a public hearing here, and that, and quite honestly, I think we can open the public hearing, we can have a discussion if you want on those, so you know what's going on, and then we can recess it and come back next month and continue.
Sounds good.
Okay,
You would prefer, would you like that?
That sounds good.
Okay, then we're gonna open the public hearing, and we'll let the applicant, either, you don't necessarily have to make your presentation now, but you've got a question right now.
Okay.
And just so you're clear on what the issue is.
Right.
Yeah.
Because, like I said, there are two dwellings right now. Both of those, they're habitable, bedroom, bathroom, kitchen, living area on a 4.3 acre lot,
It's usually not permitted.
which is normally not permitted. So, and it may not have been, it may have been that way, I don't know. Was it that way when the property was purchased by
Yeah, I can say that.
your
So-
mother, or was that added?
No, so when they bought the property, which was in like, time flies, 2000,
6 years ago.
6 years ago, yeah.
Yeah.
There were 2 buildings,
Yeah.
and they, two, yeah, what's that?
How far apart are they?
They're over 200 feet. But they're
Sorry,
just
I didn't hear
200 feet, over 200 feet, not by much, but a little bit more than 200 feet, that's one of the things we have to check. And then it's just sort of like a little living space.
One had a bathroom and a kitchen in it, and so we just
Just cleaned it up a little
it was
bit.
already there.
And then just because we were thinking about, my wife and I were thinking about buying the property from her, but if we did, we want to know that everything was above board, you know, just like you don't want to invest any more money or invest any more money in renovations, just estate maintenance, so we want to get that going. So also, so she could, in a way we buy and pay rent, it's just being above board thing. But that being said, I thought they bought it with 2 pieces and they lived in it. So I don't also realize, we were kind of wondering, what do we even
Right.
I don't know what we even asking for, because we just live our life, you know,
No, didn't
like
know
we are,
that.
so.
And that's not the problem, just knowing, number one, is, I sort of looked at it and went, how close to the property line is the auxiliary unit? Because of setback reason,
Setbacks.
in an agricultural zone or whatever, in that it may be, you know, I don't know how the structure got there.
The people before could have just sunk it in there or something like that. against the rules. Yeah, you're right.
You know, that would be a question I would like to know prior to us making a determination on this, because if the structure, through no fault of your own, is actually not legal, or was it originally a house, or was it some other structure that was remodeled or whatever?
Well, all the more reason to get the answers on it, because I mean, then what?
Right.
You still like have the title, like when they would
Oh, yeah.
sue the title insurance people when they bought the house or something.
Right, yeah. So
But, you know, I'd like a clarification, because on this checklist for special use permit, it says $600 payable to county treasurer. Copy of the deed, explicit statement of the request, scale drawing of the property showing property lines, abutting streets, names and location of all existing and proposed buildings, highway entrance and driveway parking, and proposed landscape. They have all that.
No, they don't, they're lacking a
We
plat.
don't have a plan.
But it doesn't
It's a scale
say-
drawing. It's a scale drawing. It's not a
But it
plat.
doesn't say plat.
Well, no, I mean, it's a scale drawing, not that has any measurements on it, and that what are the exact lengths of the property lines between surveying points?
Well, Ron, I think your bigger point though is section 170-28. There is a limitation on the number of dwellings per lot, and that's what you would want to look at. It says, unless otherwise permitted by provisions of this chapter, not more than 1 dwelling unit shall hereafter be erected on any one lot, unless the dwelling density is less than 1 dwelling unit per 50 acres. So that's what you might want to look at, and that's probably what would potentially be problematic.
Well, it sounds like it's not though. So yeah, I guess So I guess that it kind of goes back to we have to go. Well, again, all the more reason we want this to settle out before we buy it, so then you can go back to the person that you bought it from, and the real estate agent, because
They're not dead.
they bought the house they bought the property because there was 2 houses on it. You know,
Correct,
two,
and, and like I said, it was built in '74,
Yeah.
which is an interesting time for zoning to happen. So, quite honestly, with guest houses in the past or whatever, there was a funny rule in that it was by right, you could build a guest house, but it could have a bathroom or it could have a kitchen, but it couldn't have both.
Oh, that's fine. Yeah.
It wasn't in the code necessarily, but that's the way it sort of was. Gary?
Can I address the board?
Yes.
The health department spoke to the history of this project in their report. They said that the second building was a garage that would, in 1998, appeared to show that a bedroom in the main house was converted to an office and the garage was converted to an additional bedroom living space. So it wasn't a garage, it was an accessory to the main house. I can tell you staff's interpretation of 17028 is that an otherwise permitted by code would include an accessory dwelling unit that was just added to the code. If the body thinks it's an appropriate, use for the site, and that gets you ahead of the 1 per 50.
Gotcha.
Assuming the permit's issued. So now 17062
Yeah.
does require various issues relative to the whole site, and so you need to make sure you're hitting those. But
And, that's why I'm talking about the setbacks, in that if it doesn't meet the setback requirements, which we don't know, it could become an illegal structure, which,
it's an
could still
accessory.
get around that. but
It's an accessory. By definition, it's an accessory dwelling unit. Therefore, it is an accessory use. It would have to meet accessory setbacks, which are very minimal. So
What are, I think I haven't seen that on accessory.
that's in 170-70, right at the end of that section.
Okay,
And it can't be in the front yard. But other than that, you can be rather close to the rear property line. You can be as close as basically 10 feet or the height of the structure, and then the side, depending on where it is, 50 feet.
okay, and that was, and knowing that that's required, we need to have so we can determine that. So at least we know what we're making the permit on, and that is part of the permit, and the structure is what it is, and we recognize that fact, but we're still willing to,
The application that Ms. Ritter read off is repeating 170-57, which does call for a scale drawing showing the property lines, abutting streets, location of buildings, and highway entrances and
and
driveways.
that's what I'm asking.
So you would have to determine whether the compilation of items that they've submitted meet that requirement or not,
Sure.
and perhaps allow them to cure it if you don't think it did.
Yeah, or
We just sent a Google map and I think
So,
it should be.
we give it, so the VDOT thing is not scale drawing? It's a scale drawing, it's just not a key at the bottom.
there's no pin, on a plat map, you've got the surveying pins, and it gives you all the measurements in between each pin, and that's what you use for determining your setbacks, and that's not on that drawing.
Got it, okay.
So that's what's missing. You got, the points go all around there, but there should be notations at each jog in the line that says it's an iron pin and gives the exact location.
That is not required by the code.
But,
It does not say you need to have a plat.
Yeah, right.
It doesn't say you need a surveyed plat. It doesn't
Well-
say you need a plat by a surveyor. It says you need a scaled plan.
Right,
So
well,
this plan is most definitely
I'll ask
scaled.
then on,
but then it includes some measurements, so to speak.
yeah, so again, on that map, I tried to find a scale, and I could not find a scale.
Well, it does have measurements. You can see right here, this length is 168.53 feet.
Oh, yeah, right. Other
But
question?
you'd have to, presumably these items are all on one document so you can see.
Right.
And so what they've provided to you are several different documents, and I think it wouldn't be unreasonable for them to transfer those all onto one plan so the body can see everything together, where it rests on the site. It would not necessarily take a surveyor to do that, although
No, and
one
I'm
could.
sure you probably have it, it just was overlooked, and it's rare if
No, we don't.
if you buy a property that you don't have it surveyed.
It all started with that.
We don't have a survey, we have that.
You have, that's the tax map?
No, this is a plat.
Yeah.
They just don't happen to have a plat probably with the house shown.
Yeah, correct.
Yeah, but okay, and that is,
The word, it says same plat, but to me it's not.
I assume with all the VDOT information on there, that it's.
Gotcha, okay.
Okay, I understand,
Okay.
we can come back to it.
A couple of questions. Do they share a septic system?
No, not separate.
Separate septic?
Yeah.
It's also illegal to share a septic system, but, not, anyway, and,
Again, I'll refer you to the health department's letter that's attached to Boarddocs that addresses the septic.
right,
There's a 3-bedroom, it says
but
3-bedroom.
y'all
house.
approved that, and you had that checked recently, maybe, you know.
Yeah.
Well, the farm's okay with it.
And here's the thing that occurs to me is that the building was built illegally, and the thing is, it would probably be a good idea right now to straighten it out.
I think that's what we were trying to do.
Right,
But
and
maybe it would have been better to be quiet, but that was what we were trying to do to straighten out, because it was very ambivalent, so,
you see, if you had the plat, you could tell if other things had been done,
oh,
other untoward things have been done, but we can't help you fix something that we don't know about. And you'd
Understand.
probably be well advised to really get into this and do it right this time, you know, really.
Well,
I don't know where we go to find that other.
Going back to the septic system, from
We
the
have that
health
from the health
department
department.
report stated that there was a 3-bedroom house, but that 1 bedroom had been turned into an office, so therefore the auxiliary unit became the 3rd bedroom.
That's what we were
But
told.
you just said there's two
No,
septic,
2 bedrooms in one house, but I thought we had 2 septic.
Were there actual different septic systems?
but there's only 1 septic system.
Oh, maybe that's true.
Was it-
Yeah.
yeah.
That was,
So who should we make our little piece, our little, before we, just tell us where to go, we'll get that sheet to get that.
We go
like I
back
said,
to.
I would be surprised that when when you bought the property, that it's not surveyed. Did you pay cash for it, or was there,
That was mortgage, yeah.
was it financed? Because normally, I mean, that is a
Yeah.
standard part of any,
We just
any
have a
purchase.
file of papers and we showed it to Michelle.
It does not necessarily show the location of the house, I
Right.
can tell you that mine did not show the location of the house.
no, but at least it gives you all the points, and then you can sort of start figuring out, that.
We'll produce everything we can find next time.
I would be happy to help you create a scaled drawing based on
Well,
the information you already have.
I'm not trying to make a lot of trouble, it's just a question that I have that I couldn't answer that was an unusual plat map compared to what we normally would see.
Yeah.
Because we normally deal with survey plat maps. That is not a survey plat map because it has no point designations on it, and it's not, in fact, it's not even signed off on by a surveyor, unless that's, I don't know who Tyler and Turner are, but it's just unusual.
Okay.
So Ron, are you looking for this to help address the additional standards for the ADUs in 170-62G? So that might be something you want to look at, just so as what he's going to be looking at or what the board will be looking at.
Yeah, like I said, we're and just, perhaps having some idea of how, how they ended up with 2 dwellings on a 4.3 acre lot, and whether, whether they both meet the necessary code setbacks and everything.
So those are, you're talking about the ones in 170-70 as well.
I guess.
I'm just trying to get the applicant an idea of what the board will be looking at.
I mean, I guess,
So,
like, we want to go along, we don't want to cause any trouble, but we also don't want to, I don't know, we just have, there's a little bit kind of wanted to do this, you know what I mean? I'm a little trepidatious about, it sounds like you're kind of implying that we're gonna take a retro look at the whole property and what's there and stuff.
We'll look at all the papers and we'll come back in a month's time.
Well, like I said, historically, I think that's relevant to
To
the
the new thing.
application, or it could be, like I said, down the road, it could be relevant for you
That's
with
right.
Salem, and then all of a sudden, there's something would come up on a title search or whatever, as far as, how did this house get here, or the second dwelling, because like I said, back then, things were what they were,
We
as
don't
long as,
know.
as long as
It's
it's
a garage, so they got the building in as a garage.
but even as a garage, it has to meet certain
But it's
setbacks.
permitted,
Well, yeah, right,
on-
it has a permit.
it's permitted as long as
Accessory
there's 2
setbacks are
acres.
very much
Come
more
on, guys,
more
it's
relaxed than
permitted
regular.
if it's at least 2 acres,
Right.
that's what it says in the code.
Right, and I think that, I think it's been pointed out that accessory setbacks are far more lenient than regular domestic buildings.
I think the question is the dwelling, that's the key, not the accessory unit, the dwelling unit is the key.
Right, but now it's become a dwelling unit, so now the question arises.
But that's, like I said, this is kind of new to us, I think. the dwelling
It would have been a
unit. So I
family
think-
apartment.
So I think we need to,
Yeah.
establish.
Then you go to
Make sure
Exactly.
Which is gone now, it's the ADU.
Yeah, so that makes it right, and in the future, we know how to move forward.
Okay,
Okay,
we good.
We just need a tight package and all that stuff.
well, I just
And
think
you
it
don't,
gave us
and you don't
what
need
they
to move
were
in next week. In
required.
fact, you may have moved in already, you're just trying to get it straight, so, and I've got no problem with that either. So, okay, at this point in time then, if everybody's asked their questions or whatever, we'll recess the public hearing until November and move forward at that time.
All in favor?
All in favor? Or second?
I,
We have a second?
I'll second, yeah.
Oh, okay. All in favor?
Aye.
Okay, we're good to go.
Can I just ask you one question, Lisa? You bought it with these 2 units on it,
Correct.
correct? Yes.
Nobody goes and looks at the code before they buy things. And nobody reads things like that, but, you know.
Are you going on? All right.
All right, thank you.
Very much.
Okay, thank you.
See you next
See you next month. Okay, old business. We have the annual report, which has never been completed for 2020. And it is required by code, but it's, other than it being required by code, it doesn't spell out exactly how it has to be submitted. And maybe Gary can help us out with this, in that I believe if we would take the minutes from our meetings in 2020 and submit them as an annual report, that could that be the requirement?
Mr. Curry, is it really just a summary of SUPs and variances and how many were approved and denied?
Nobody's gonna-
I can tell you, I don't know that the code specifies. Please don't just send all the minutes. If you want to do that, send a letter that says our report is all the minutes, go see the minutes. There's no real need to do that.
Well, like I said, I doubt if they're gonna read it anyway.
But I think it would just be a summary for the record books, so that in 30 years, when someone goes back and looks, they don't have to look at each individual action. They can pull this and see the highlights of what happened. And that might include significant changes to your rules of procedure or whatever.
If it
Okay.
pleases the board, I'll take the
I was
action
gonna
to
say,
summarize.
if you're comfortable with just going through and putting that down, then we'll submit that. Okay, we need to submit something, and whatever's the easiest or what we're willing to do works for me. Obviously, it works for everybody else.
I'll bring it for the November.
That'll work. Okay. Now, it would be rules of procedures, proposed changes, which actually what was in the board doc was not exactly what we were looking for, and that or at least I was looking for, I was looking for more of the proposed wording, which we have in the minutes that we just passed, and we can reference it that way. So basically, the proposed change is on Article 6, Section 2, and we're going to add wording in the beginning, which states that that this particular section is for variances and appeals. It might be easier to just, rather than saying it doesn't apply to SUPs, to say for variances and appeals only if the applicant or appellant is a legal entity. And then it goes on or whatever.
I tried to ask a question today, and I wasn't making a connection. Your rules of procedure, Article 10, Section 10.1, speak to how you're going to amend these rules of procedure.
Right.
And they say that they may be amended by majority vote of the BZA at the next regular meeting following a regular meeting at which notice of the motion to amend was given.
Right.
So you included in your minutes the change that you agreed to make at your last meeting. So are those the changes that you're going to vote on tonight?
Correct. And it was
So
on
I
the
would
agenda
suggest
in
you can't
August.
change them.
It
And
was-
if you change them, then you vote on them at your next meeting.
One word?
It's your rules, not my rules.
Okay, no, that's what I'm saying. In looking at this, and I don't care, we could continue to the next meeting, but I was from an understanding point or whatever, because at the end, and the reason I'm saying that is that when it says, this rule does not apply to SUPs, that could be a little confusing to someone in that they might, if they chose to appeal the decision on their SUP, they might think that they would not need an attorney for that, but in fact, that becomes an appeal, and then they do. And that, because that ends up in the circuit court. So that was why, that's when I read it and thought about it, and I thought that's, that last sentence could be a little confusing.
Well, a couple of considerations that I was thinking of as well is, one is, what if in the case of a SUP, even though it is not a legal entity, the person starts referencing case law or things like that, where I think we've had brought this up before, where it kind of, it veered into what Mr. Lockerbie said in accordance with the unauthorized practice of law statute. So maybe we just kind of blanket cover by referencing that statute.
It's really hard for me to understand, to see to understand how one references the law when is practicing. I mean, it doesn't really follow. One can reference law without practicing law, but one can be accused apparently of practicing law if one references it. And I find that very confusing.
Well, because the difference is that as an individual, you can do that, but if you were doing it as representing a corporation or other legal entity, then you are no longer an individual, you are the entity.
What if you're
And
the
that's
sole-
what the state code references.
What if you're legally the sole proprietor? That makes you, if you have a business and you're legally the sole proprietor, that suddenly
Then you're
makes
not a
you.
corporation, you're not an LLC.
So you can be incorporated as a single person. I mean,
well,
you have to have
that
couple
is
people
why
on your board, but what is that?
Well, based on our rules, if it's an appeal or a variance, they would have to bring counsel. That's what these rules are stating.
Right, I understand that. I understand that. I don't. That's above and beyond what the state requires, right?
Not
That's not
necessarily.
what Mr. Lockerbie said. He
This-
said for legislative actions like special use permits, it's
Right.
typically not required to have legal representation.
We cannot require it.
He did not say there was that hard and fast requirement, he just
Right.
stated what he had observed in other jurisdictions.
Right.
So, but for quasi judicial actions, then, yes, absolutely would require legal counsel. And he even himself referenced the unauthorized practice of law,
And a quasi,
judicial matters.
the quasi part ends up being the appeals part. And when you appeal a decision that we made, you appeal it to the circuit court.
Right.
And now you change venues there and the requirements change. So
They're definitely required to have counsel.
correct, that's what I'm saying. That's why I thought it was a little confusing with, it says the rule does not apply to SUPs. That might lead people to think that if they appeal it, not knowing, the inner workings or whatever, that they wouldn't need an attorney. So to just have it written that
Right.
for variances and appeals, this is the case. And it, applications for SUPs don't.
Are you suggesting we just strike that last sentence?
Well, it depends on how we deal with it. I mean, like I said, the way it's written right now is confusing. And we could change it to, a separate section for SUPs, and that, the applications for SUPs do not require, or actually maybe that would be better as the first sentence.
You might
And
say
then
that
for variances and appeals, the applicant or appellant is a legal entity.
for full disclosure, you might say that they are not required for the application, but if you have an appeal, this may not be the case.
Correct, that's what I'm saying.
Right,
And,
so
so that's
it's fair to tell people that.
Just,
And,
it was just a little confusing the way it was written.
Right, well, I thought so.
And like I said, if we want to change that and take care of it next meeting, we can do that. Plus,
Yeah.
if that's what we want to do, and we're discussing it, I would also make a recommendation that we add a section, because, I mean, probably never happen again, but it did happen, it has to do with resignations from the board, and there are, it was Ken Ryko or somebody that basically just had in there is that if, you know, if you resign from the board, your resignation is the date of your resignation unless you specify a specific date.
That's the termination,
That's
the
But it has to
termination
be-
date is the date that the letter is posted or
It is,
received or
if
something.
it is not specified in the letter of another date, but it has to be a date, it can't be a nebulous
Right.
time, so that, you know, and just to throw that in, here it is. Resignation. Any member who resigns from the BZA prior to the end of their term shall do so in writing to the chair, that's understood. The effective date of such resignation shall be the date of the letter to the chair unless another date is stated within the letter of the resignation.
Yeah.
And we just add that term under, it would come after, or wherever we have it in our rules here as far as expiration terms, and you put it in with that category, wherever that is.
Section 2-5 is term of office, 2-6 is vacancies in office.
Vacancies, yes. Vacancies in office should be filled as soon as practical.
These offices are your chair
Term
and
of
vice
office.
chair, they're not your appointment term, that's
Right.
distinct. So Article 2 is about officers and it's not about BZA members.
Oh, that's right, okay.
There is no section that is really applicable.
No, there is the section someplace where, you know, if your term expires, that you continue to serve until replaced.
Well, that's the Code of Virginia.
And to add it into that section, wherever it is.
Are you saying that the code, that's the code of Virginia, are you saying that unless the code, why don't we just let the code of Virginia apply?
It's not, it's,
But
quite honestly,
you go until you're replaced unless you write a letter and resign, you know.
And my point was the Code of Virginia sets that you will serve until a replacement.
Right.
If you want to add such a term, I would think you would put it into Article 10, rules. You have amendment, you have suspension, and then any rules of, then it talks about Robert's rules. That's, I guess, a catch-all.
okay, yeah, that would work. It just, you know, like I said, it just makes it clear, because it was not, you know, the section you're referring to is specifically was talking about expiration of term.
Right.
And that's different from resigning, so,
Right.
so to have, you know, and like I said, this is from Herndon, town of Herndon or whatever, but, you know, like I said, and it's right there, and it's under term of office, and then it says resignation. But under term of office, it says you serve until you're replaced, unless you, and then below, unless you resign, this applies, so.
Right. Then we have a specific wording for this we're proposing that we can vote on?
I'm
So
not making reinventing the wheel, I think what Herndon County says applies pretty well.
But where are you wanting to put this? Under rules or
Under wherever it says terms of office.
It doesn't say
And I'm not-
I think we, as Mr. Curry indicated Article 10 would probably be the most appropriate place. But can you make a motion on what the exact language is again, please?
And do you want to add it as 10-3 and then
Right there.
change 10-3 to 10-4? And how are you intending to do this?
Is that,
I mean, I'm good with the statute of Virginia's, rather than being more specific.
well, that was the problem. The statute of Virginia does not deal with resignations.
Right.
The word is not mentioned. That was what I looked for before our last meeting, was trying to find something, and the only the only reference in state code as far as resignations was in the administrative code, and it had to do with resigning from boards. But there was nothing that mentions resignations in the, particularly in the BZA or in anything having to do with board members. I don't know why, but
Mr. Craig, do you have clarification on this? For how about
so it's
resigning?
not that big a deal, but it's just, you know,
Resigning from boards?
I don't think that administrative code section probably applies to whatever it is.
like I said, that was the only reference I could find in the state code though, unless you found one.
No, but I think as was pointed out, Mr. Sharp's been was on the body for 20 some odd years. It was probably the first time it ever happened in his tenure.
Yeah.
30, I think, actually.
You know, I don't know that you may be putting a solution in for a problem that almost never happens. You can do that. If you want to set the rules of the game right here in your rules of procedure that says if you resign, you must state the effective date of your resignation. If you don't, it's when you submit the piece of paper. You can write that in there.
It's two sentences, it just clears up, so and actually if a board member is gonna resign, you can go, okay, it's right there, I know what to do, I'm supposed to write a letter to the chair, because quite honestly, you know, and it should be in writing, and that, I mean, there are times,
Well, that
somebody may
resignation,
call you up on the phone and
the
go,
resignation
"I'm
should be to the circuit court,
Yeah.
not the.
It doesn't-
They don't resign their seat to this body. They resign their seat to the circuit court, who appointed them. So, now, if you want to have rules that say, you know, what that means,
Is,
I think you can bind yourself and bind.
so in the, that's what I haven't read then or didn't find is that, you're saying that someplace is written down that if you're gonna resign from the BZA, you have to submit your resignation to the court.
Yeah, because the court appointed you.
That's what,
Is it written down? That's what I'm asking. That's why
I
I could find nothing that was written down. That's where I was confused. And I was looking everywhere trying to find something about resignations, and I couldn't find anything. That's why, and then when I found this, I thought, well, that, you know, that pretty well spells it out in two sentences, and it, you know, it can be a matter of great debate or not, but it's, if the board's not interested, then fine.
Nothing went badly last time. Well, it was all fine, given the rules that we were following.
Well, I mean, do you wait till it goes bad to deal with it, or just
Yeah.
deal with it? Yeah. Okay,
Okay, well, what's the proposal?
just basically two sentences. Any member who resigns from the BZA prior to the end of their term shall do so in writing to the chair, and then the chair can notify the,
And they have to do it to the chair and the court. The court appointed them, the chair has nothing to do, you know, they're just telling the
How
chair
about
what's
to
going
Yeah,
on.
that's
the
fine.
court with a copy to the chair?
Yeah.
that would be fine, yes. That's good. The effective date of such resignation, and well, and now quite honestly, if the resignation is made to the court, then one would think that the court has some rule or something that determines when the resignation takes place, and that, you know, Mr. Sharp made an offer to the court to serve until replaced, but that was an offer, and it was based just on his personal feelings or whatever, and I don't even, you know, I see the court ignored it, you know, whether did they ignore it, did they write back and go, did he receive a letter back saying, okay, we recognize you're going to do that, and we accept your offer to serve until the end, until we replace you? I don't know if that took place. I doubt it did, but you know, that's what I'm saying. It's just, you know, it's in writing. Everybody can, you know, see it. Everybody's on the same page, and there's no questions. Because I mean, it was a question last time, and it had to do with the fact that if decisions were made on a close vote, possibly there could have been a problem in that if, in fact, Alex, because he had resigned, was not a member of the board at that point in time, his vote would not count. And, you know, there wasn't an answer, you know, on that. I mean, that might be, you know,
Can I say something? My understanding of the way the court operates, Rappahannock, we're like the tadpole in the pond.
okay.
And Loudoun County sort of takes their sweet time. I don't know if I should be saying this on the record, but dealing with it. And I believe that happened with
Yeah,
your.
4 months, right.
Right. And I know when I talked to Peggy Ralph and said, so how does this work? When does it happen? And she said,
Yes.
when the judge gets to it.
Right.
So you could conceivably have a situation if you put a hard, fast rule in here and say, okay, you resign, bada, bada, boom, it's effective as of the next meeting. You could wind up with 4 people. And it could take a while to appoint the 5th, in which case you conceivably could tie. And maybe that's not
Right, so
important, but it's
It
a
is
consideration.
we, then, you know, unless we are, you know, going too far or whatever, to say that if you resign, that you will be considered a member of the board until you are replaced.
Yeah.
So then it's clear. But right now, it's
Okay,
not clear.
that's good.
Okay, that's good.
And I don't care which way it goes, as long as, you know, we know what the rule is.
Okay, so you want any BZA member who,
Quite honestly, I would like to see something in writing. It can go either way, like I said, if we want to write it such that you serve until you're replaced when you resign, that's fine with me also. But that way, you know, we know.
You might be serving from 3 states over, but you're serving.
But,
You may be serving from 3 states over, but you're still serving.
basically, yeah.
It's not sensible.
Well, that's what I'm saying is that, you know, if you suddenly have to leave or whatever.
It's really not
You could come in on Zoom and attend the meeting, even though you didn't live here anymore. And is that what we want?
No.
Okay, so we're back to where I was, and it needs to be known.
You have to have citizens on this board.
Well, absolutely.
So if
That's-
someone moves to Detroit, well,
The Code of Virginia actually does require that. The Code of Virginia actually does require that. You must reside in the county to be on.
right, exactly, yeah, and that's what I'm saying, you have to have, you can't, you know, there are certain circumstances in which that would not work at all. The person would not satisfy the Code of Virginia regarding the constitution of our body.
Therefore,
I think it was resolved, I mean, even though it got a little messy last time, I think you did a great job of resolving it.
well,
I mean, and it came out right, nobody was really grumpy, and
No,
Alex was comfortable with it, and then everything worked out, so somehow I think maybe what we've got, it will serve us well.
what we have is nothing, so.
Right.
We can stay with
But we
nothing.
worked with it,
Because
you did a great job.
nothing sometimes serves you well, and sometimes it can't, so.
Okay,
Like I
how
said,
about this? Any BZA member who wishes to resign shall send a letter with the date of resignation to the court and
Yeah.
copy to the board of the
Right.
BZA.
Good.
That sounds good.
Yeah, so, you know, for somebody that knows 3 months down the road, they're transferring, moving out or whatever, they can resign and say as of such and such a date, so, yes, and then an appointment can be made, and the appointment will be effective on their resignation date.
Right. Well, the court is quite prompt in their filling the seats, they don't waste a lot of time.
Oh, yeah, they do.
They do waste a lot of time.
That's why I'm saying this also.
I don't think we have the pudding here.
Anyhow, okay.
Are we making a motion?
Do you want me to restate it, or do
Was
so?
that a motion? Or-
I would go with what you wrote there, that's fine.
That's fine.
And so you're making that as a motion. I'll second that. All in favor?
Aye.
Okay, so we'll include that in our next meeting also when we make the change on the application for BZA. And are we, the wording on that, where are we at on that? For the variance?
This is what we're doing for the word right here.
I mean, basically, I would add on 6-2 for variance and appeals only, and put it in that way.
Or just strike the last.
And then strike the last one, because it says nothing about SUPs, and so it's not, it doesn't get confusing there. But if an SUP gets appealed, it's not an SUP anymore, it's an appeal.
Right.
And another one, because it's not that late. On our annual meeting, which I believe is in our procedures. Gary, is that strictly in our procedures or is that in the county code also? In that we run into the problem of the,
I thought we moved it.
we didn't deal with that. You know, we have now twice made the recommendation in December and then had our annual election in January. But it would seem to me that the process should all take place at the same time. And as I stated the last time, is that if we do it in December, it gives the individual that's elected a month to, you know, get their act together or whatever. So from January meeting, they sit down and have some idea what they're doing, rather than the way it is in with like the Board of Supervisors, is that the change takes place immediately on the vote.
So the 170, 139 Planning Commission sections, what you're speaking of, Section C, titled Membership, subparagraph 2, is where it states that I believe that's right. Members shall be appointed for 4 years, and terms of appointments shall be staggered. However, members concurrently serving on the Board of Supervisors and the BZA shall serve until at the next for annual regular meeting of the Board of Supervisors, his or her successor is appointed to serve as a representative of the member. Bottom line is that the Board of Supervisors will appoint a BZA member to the Planning Commission at their January meeting. If you want to have a say into who you recommend for that, you better do it before the January meeting of the Board of
That's what we
Supervisors.
decided, right?
But we haven't changed it in our rules that I
It
remember.
says the meeting in December.
Yeah,
Does it say that?
yes.
Yes, I remember we voted on
What's the number on that?
it. It's Article 3.
Section 3.1, annual meeting. The meeting in December of each year shall be the annual meeting. And nominate a member to serve as a representative on the board to the planning commission.
Oh, okay. Oh, okay. From the things it's. So that, they made that change in 2019 then, May of 2019? Okay. Sorry. Right back on.
That's no good to review. We actually did discuss it and we voted on it and changed it.
Okay.
Would,
Yeah, okay.
are we gonna make the motion on 6-2 as far as the language?
I don't know that you necessarily, reading section 10.1, you need to, you can make the change at the next regular meeting following a regular meeting at which notice of the motion to amend was given. So you need to provide notice to everybody who's here.
Yeah.
You're going to talk about this, and I interpret that to mean what you're going to change.
It doesn't.
And the idea there is that you can't just make a change on the fly
Yeah.
during a meeting.
Right.
However, that really doesn't matter because 10.2 says you can suspend your rules if you want. So,
Absolutely.
but the intent for 10.1 is that you're going to think through changes to your policies, and you're going to not do it at the meeting you come up with. You're going to do it at your next meeting, and it should be clear to everybody in attendance what that's going to be. And then in your next agenda, you can have that clearly outlined.
Yeah.
This is what we contemplated, and you can the world can see it when you post your agenda. They can come see and say, no, you don't want to do that because of these reasons that you didn't think about before.
Okay,
Okay,
I'm persuaded.
so that would be our next meeting, then we'll do both of those changes and life will go on. Your board. It's in your board? Okay. I think we're, next, we have one order of new business, and that is the resolution, which I believe everybody will join to. I'd like to publicly thank David Connick for putting this together. He did a very good job of it, and actually it could have been 2 pages, but there's a resolution, and it needs to put on an 8x10 sheet of paper. So if we've all read it or whatever, do I have a motion to?
How about you read it so that people
Yeah, why don't you
know
read it?
what it says?
Excuse me. That's right. Okay, resolution of appreciation. Whereas Alexander Sharp, the 7th, has served on the Rappahannock County Board of Zoning Appeals as representative for Hampton District from blank, because you're going to have to determine it was a long time ago, 20 years,
1990.
through September
I don't know.
2021.
I believe it's 1990.
What?
I think it's 1990.
1990, okay, well, that's, like I said, we'll need to check on that to make sure it's correct. But anyways, whereas Alex's dedication to his responsibilities, his leadership as chairman, his congeniality, his concern for the community, and his dedication to sound land use planning in Rappahannock County has been manifest through all of his years as a member, as chairman, and as representative of the BZA to the Planning Commission, and now, therefore, be it resolved that the Board of Zoning Appeals for Rappahannock County does hereby express its sincere appreciation and thank Alex Sharp VII for his leadership and long distinguished service to the board and to the county. Be it further resolved that a copy of this resolution will be spread across the minutes of the Board of Zoning Appeals of Rappahannock County, and that a presentation copy be provided to Alexander Sharp VII. Adopted October, what is it today, 25th? Yeah, 25th, 2021.
27.
27.
27.
So that is the resolution,
Here.
Here.
and are we all in favor of
This
this?
is the vote. Who moved and seconded?
Didn't even discuss it.
Who moved and seconded?
Oh, okay, yes, who moved and seconded?
I'll make a motion that we
Okay.
adopt the resolution as written.
I'll second that.
With the addition of the starting date.
With, yes. Okay, all in favor?
Aye.
The motion passed. We will have this written up as it should be with the correct dates in it, and we will all sign. I think we need to get it in a better looking copy or whatever. And then, so at the next meeting, we can have it and sign that copy. Okay.
We need bold lettering and seals and.
And one other item, and because there was some confusion, I think, with Bill. You had a question about SUPs and.
Well, here's the thing, I've taken this course, and the problem with where I became disjointed was that they state the rules for they're just involved with the state. In our rules, we have more stringent that's apparently supersede that, and so it's just, I no longer have any question, we just have different rules from the state, we just add more restrictions or more conditions than the state does, and that's our prerogative.
Well, I mean, yeah, it had to do with findings, but you were unsure of, I mean, the findings are 170-15
52.
Oh, yeah, well, I have a copy right here.
Yes, okay, and that is the one that states that when you do SUPs or whatever, that we have to do, there's the general, what is it, the general standard, they're called general standards here, but in fact, they're findings.
Right.
And that, it's 175.
And so
yes,
have you been reading? I
we
just-
do have to, we do have to go through this list.
Right.
Or just,
No,
we
the county
can
does that,
say,
it's St. Louis.
we can say, as we did tonight, that there were nobody had any problems with 170-52, and so it was an understanding, and that's acceptable. I mean, because there's a lot of, it goes all the way through J as far as,
Yeah.
it's very time consuming, but if nobody has any problems, you can just sort of do it by acclamation or whatever. So just launch it, go straight into that. Okay, so motion to adjourn,
So moved.
I second.
all in favor?
Aye.
Okay, and we have some documents for that, some sort of lead document for that.
That's got science.